what the country did, what this particular regime did, because it is said that these refugees have been here during the late Mwai Kibaki's regime. They were here during the former President Uhuru Kenyatta's regime, but President William Ruto's regime decided to forcefully return them to their home country. Was it done was it done legally? Was it an issue of betrayal? Were the rights of these particular people protected, given that they ran away from their home from the fear of persecution, and now they're being returned forcefully?
The refugee, let me start with the international instruments.
Mm-hmm.
The Vienna Convention of 1951 relating to refugees, mm-hmm. Under Article 33, under Article 32 and 33, prohibits the forceful return mm-hmm. of refugees back to their country of origin, mm-hmm. In view of the real threat of persecution. Mm-hmm. And therefore, and Kenya is a signatory to the 1951 convention. Mm-hmm. Kenya is a signatory to the 1969 OAU convention. Mm-hmm. And therefore, Kenya is bound by these instruments. Mm-hmm. And Kenya must respect those instruments in good faith. Mm-hmm. And that is also founded on an international law principle known as Pacta Sunt Servanda, mm-hmm. which means that an agreement must be respected. Okay. So the 1951 Vienna Convention must be respected. The OAU Convention of 1969 must be respected. Mm-hmm. And any other international human rights instrument which Kenya is party to. Mm-hmm. Locally, you have the Refugee Act. And the Refugee Act is, in fact, very detailed in terms of protecting refugees, and particular, ensuring that they are not, their status is not changed to their disadvantage. Mm-hmm. For example, if you look at the Refugee Act, under Article 17, you cannot, there are conditions upon which the refugee status can be cancelled, mm-hmm. and very elaborate. And even where you cancel, if you now deem them not to be, fit to remain in your territory, mm-hmm. you give them 30 days to leave. Yeah. You don't return them. Mm-hmm. You give them 30 days to leave, and this is done by the Commission of Refugees. Okay. Under Article 18, it is, if a country believes that refugees, for example, have committed an international crime, mm-hmm. then the commissioner again mm-hmm. can, the commissioner again can expel. Mm-hmm. And again, that requires an elaborate process, which includes due process. You must take them through due process and prove that indeed they have committed those crimes that you claim that they have committed. Mm-hmm. And the cabinet secretary can also, I think under Article 19, revoke, okay? Basically, 17 is to cancel by the mm-hmm. commissioner. Mm-hmm. 18 is revocation, okay, where there are international crimes, which are, where there is belief or there are reasonable grounds to believe that international crime could have been committed. Mm-hmm. Then 19 is to expel, mm-hmm. okay. Yeah. To expel, and this can be done by the cabinet secretary. And even where the cabinet secretary decides to expel, then again there is need for due process. Okay. They must be subjected to due process, mm-hmm. meaning that you cannot just, for example, on flimsy ground, claim that they have committed a crime without proof. Mm-hmm. So therefore, it is very clear that 17, 18, 19 provides for due process, and it does not provide for their return to their country of origin.
Yeah.
You give them now the opportunity to relocate to any other territory.
Okay.
And there is also the, if, for example, they have families, then their families are now entitled to apply as separate individuals for refugee status.
All right.
Okay? So you can actually see how elaborate the process and the protection mechanism is under our constitution. And then you have Article 29, which now provides for non-return or non-refoulement, non-return, meaning that a refugee cannot be returned to the territory from which they fled from because of well-founded fear of persecution.
Yeah.
And even where you, and this is, for example, if you even under 33 is a non-refoulement. You should not return them to a territory where they fear that they will be persecuted on well-founded grounds. But 32 talks about their expulsion. And 32 provides that even where you must expel them, and this could be on the basis of national security, then again you must again subject them through due process. So that, the claims that you have against them as being a threat to national security are proven in a court of law.